Okay, share screen. Are you able to see my screen now? Great.
Yes, not in presentation mode, but we can see.
Yes, you will soon see it in presentation mode. There you are.
Yes.
So just some housekeeping remarks. As you all know, we will have some 20 minutes presentation with a break in between. And in this session, we will present the ethical, legal, and social aspects of the urban lighting project. We don't have guests yet, but they will join. So this introduction will only be for us for now. I remind you that the session will be recorded for monitoring the project advancements. So just to let you know, and if you agree, also the presentations will be available for the rest of the group afterwards. Just a brief introduction. So in this session, we will tackle the ethical, legal, and social aspects of urban lighting. There are diverse areas to be investigated and in which ethical, legal, and social aspects play a major role. Environment, big data, human health, social spaces. We won't be able to tackle extensively all of them, of course, but the group is working on the different areas with different expertises. Those areas are also reflected in correspondent research questions that we try to showcase in this session as good as we can. So ethical and legal and social aspects of the clinical studies that collect data and samples to monitor health changes for people that are exposed to light in different settings, data-intensive studies for which we collect quite an extensive and intensive quantity of data in order to ensure that the project can be monitored and produce results. Social aspects, how urban lighting is impacting the social life of people. And yesterday we had a very nice session with Don Slater. The ethical implication of urban lighting that Mirko Ancellotti will present later. And last but not least, ethical implications of research. How do we conduct the proper research so that we make sure that we produce good quality and respectful research? So this is pretty much the overview of the session. We will have Andrea Parziale presenting on research on health and urban lighting between open data and data protection. As we know, the study of health in relation to urban lighting poses some challenges of the extensive and intensive collection of data and biosamples. Those challenges are especially relevant today inside the push for data availability and big data. How should we deal with human health data to be able to use them efficiently, but at the same time ensure privacy rights and like the security of the people involved in research? Kira Stanton will proceed presenting the controller processor or joint controller issue, which seems quite a dry legal issue, but in fact, it's really looking at how we can ensure that rights and responsibilities will be distributed so that data subjects are protected in the best way. Many partners from international consortia are creating a very complex legal landscape that is not easy to address, and we really needed to investigate and regulate some aspects that do not have all the rules defined yet, and that's why we are looking into those issues. This also means that we need to look into how researchers take responsibility for research, and Elisabetta Pulici will present on data integrity and research integrity. So how we do create a research complex environment by rights. Last but not least, we will look into the more theoretical ethical setting of the research. So how is the ethical discourse impacting urban lighting? How is light pollution situated within the justice discourse? How can we frame our research and our policies so that those elements are taken into account? We will try to tackle these issues in the time we have. And for that, in order to have an efficient presentation and discussion, I would like to remind you some housekeeping remarks. The session is recorded, as I already mentioned. You can write questions in the chat, but you can also intervene live if you have burning questions. We will have 5 minutes questions after each presentation, but then we will have a final bigger discussion. And I plan to have a break that may be shorter or longer, depending on how much interaction we have after the first 2 presentations. So I will leave now the word to Andrea Parziale, who will start his presentation on the legal aspects of data. Let me just stop sharing and leave the power to Andrea. Welcome, Andrea.
Thank you, Deborah, for your introduction. Good morning, everyone. So let me share my screen. Okay, so I think you can see it now.
Yes.
Okay. Just for the sake of ensuring a stable connection, I will disable my video to be sure that everything goes smoothly. Okay, so thank you again, Deborah, for your kind introduction. Good morning, everyone. I would also like to thank the organizers of this conference for giving me this wonderful opportunity to chat about the tensions and interactions between open data and data protection. This is a key aspect for our project, as emerging also from the data management plan template that we have drafted and that we will need to update seamlessly. And in fact, the overall aim of this presentation is to outline some general considerations to start the discussion on how to share the project data while ensuring compliance with data protection law. And of course, in addition, this general discussion is also potentially relevant to any other research initiative that aims to ensure the long-term value of the data produced and the respect for and compliance with data protection law. So here is a summary of the points that I will cover in this presentation. First, I will describe the open data philosophy and promises, and particularly the so-called LOD principles. Then I will turn to the FAIR principles that are nowadays recommended in virtually every EU-funded project, including our project, ENLIGHTENme, and I will consider their interaction with data protection law in very broad terms. Building on that, I will finally sketch some preliminary recommendations on how we could ensure not only that data protection law, that the data verification is compliant with data protection law, but also that data verification actively supports the implementation of data protection law principles and the rights of data subjects. So what is open data? Open data is the idea that data should be freely available to everyone to use and republish as they wish, without restrictions from copyright, patents, or other mechanisms of control. So according to its proponents, open data has the potential of serving key social public interests. Among these are transparency, public participation and accountability, and ultimately economic growth and innovation, in particular in research, Open data is believed to be essential for reproducibility and self-correction of the research process itself. Open data fosters innovation and accelerates scientific discovery through the reuse of data, both within and outside the academic system. At least this is the philosophy, the spirit that animates the proponents for open data approaches. It is therefore no chance that this philosophy of open data, the open data movement, has inspired several different policy initiatives around the globe, both at the supranational and at the national level. Here is a list of some examples coming from both levels. For instance, the OECD principles on access to research data, general statements by the G8 representatives, and the European Commission Horizon 2020 Open Data Policy Pilot launched in 2014. Open data proponents also tried to devise more concrete guidance and principles to help translate open data from a promise, from a philosophy, into a reality. And among the first attempts at these are the so-called LOD principles. These principles were outlined back in 2006 by no less than Sir Tim Berners-Lee, a prominent English computer scientist that is best known as the inventor of the World Wide Web. LOD stands for linked open data, and these principles basically state that you should make your stuff available on the web in whatever format under an open license. And of course, stuff includes data. Make it available as structured data in a non-proprietary open format. Use URIs to denote things and link data to other data to provide context. In 2010, Sir Berners-Lee suggested a 5-star scheme for these principles, starting at 1 star, with data getting more stars when proprietary formats are removed and links are added. So the more data is open, the more stars are added. These principles have not actually been really widely adopted. However, they perfectly embody the spirit of the open data movement, as well as its limitations. Among the main limits of this movement is that it basically fails to address the potential harms of unrestricted access and use of data. Indeed, when it comes to personal data, privacy and data protection risks may arise. Data may be used and abused for illegitimate or inappropriate uses, such as for employment and insurance discrimination, for social sorting purposes, and so on. So these risks are all the more relevant when sensitive data like health-related or genetic data are concerned. And if not adequately tackled, these risks may frustrate the very objectives of open data proponents, because unmanaged data protection risks may indeed not only result in legal liabilities, fines, but also discourage people from participating or continuing to participate in research initiatives. So against this backdrop, the FAIR principles offer an alternative approach. The FAIR principles state that data should be made findable, accessible, interoperable, and reusable. They have been first proposed during an international conference in Leiden in 2014 and have been formally outlined more in detail in a seminal and extremely cited paper by Wilkinson et al. That has been published in 2016, which frames the FAIR principles as principles not really of open access necessarily, but as principles of data management and stewardship in terms of long-term care of the data. In fact, while it is common wisdom that the FAIR principles are an example of an open access approach, we will see that their underlying philosophy is much more nuanced. In particular, findable, accessible, interoperable, and reusables are the foundational FAIR principles, and each of them is split into more specific guiding principles as follows. So to make data findable, these are the guiding principles. Data and metadata. Metadata are data about data, so they are descriptions of the data. So data and metadata should be assigned a globally unique and persistent identifier. An example of this is the digital object identifier, the well-known DOI. They should be described with rich metadata, and we will see in a minute what this means. They should include the identifier of the data described, and they should be registered or indexed in a searchable resource. Then to make data accessible, data and metadata should be retrievable by their identifier using a standardized communications protocol, such as the HTTP. The protocol should be open, free, and universally implementable. It should allow for authentication and authorization procedure where necessary, and this is a key aspect. Metadata should be accessible even when the data are no longer available. To make data more interoperable, data and metadata should use a broadly applicable language for the representation of knowledge. They should make use of vocabularies following the FAIR principles and include references to other data and metadata. Finally, data should be made reusable. So data and metadata should be described with a plurality of accurate and pertinent attributes. They should be released with clear and accessible data usage license. They should be associated with detailed provenance and meet domain relevant community standards. So all these principles have some shared characteristics. First, they are functional in nature, which means that they describe the objective that should be sought, but do not really state in detail how these objectives should be achieved in practice. Secondly, they are technology neutral. Thirdly, they may be implemented in degrees. So a resource, a data or metadata could be more or less findable, more or less accessible, and so on in degrees. And finally, the FAIR principles aim to maximize access and reuse of data, not only by humans, but also by machines. So the FAIR principles' overall flexibility makes them much more universally acceptable than other more rigid open data approaches, such as the LOD principles. Importantly, the FAIR principles are not, or at least not necessarily, about open data. In fact, the A principle, the accessibility principle, does recognize, as we just saw, that sometimes it may be necessary to implement authentication and authorization systems. And one of the main constraints to the accessibility and the reusability of data comes in particular from data protection law. So in particular in the EU from the GDPR. Indeed, the GDPR principles overall run against a drive for the systematic and automated access to and reuse of personal data. This is because for data to be processed, there must be a lawful basis for the processing, basically consent of the data subject or other lawful bases as relevant, such as public interest basis. Data must also be processed for a specified purpose. The data to be processed must only be the data that are strictly necessary to achieve that purpose. This is the principle of data minimization, and relatedly, storage limitations. So the data can be stored only for the time necessary to achieve the purpose of the processing, the specified purpose of the processing. In addition, the data subjects, the individuals, have several different rights in respect of their personal data, such as the right of access to their data, rectification, erasure, and so on and so forth. If data are processed for research purposes, some exceptions may apply. For instance, further uses of the data for research purposes are considered compatible with the initial purpose, and this is an exemption from the purpose limitation principle in a way. However, this exemption, and in fact, all the research exemptions, are only allowed if appropriate, in particular, if appropriate safeguards are implemented to protect the fundamental rights and freedoms of the data subjects. So this overall regime, this overall set of principles, ultimately prevents any scenario in which the research participant just gives away their data to be used for unspecified purposes and in lack of any kind of control or oversight. This conclusion has been confirmed by a 2018 paper outlining the so-called fair health principles. These are principles that aim to guide researchers in the verification process of health data. For instance, these principles recommend that there should be a clear identification of the responsible data controller for any biological material data set. The compliance of the research projects with informed consent should be ensured, and the ethics approval of the research project must be assessed before granting access to sensitive data or biological material. The principle of data minimization must be upheld. Privacy enhancing technologies should be implemented. Mechanisms to facilitate the withdrawal of consent should be in place, and so on. So while these principles provide some general guidance, they still remain quite high level. They may be actually translated into a general recommendation that the verification of health data should comply with both data protection and research regulations, which is a bit of a tautology. So against this backdrop, very few scholars have attempted to provide more concrete guidance on how to verify data, research data, while respecting data protection law and data subjects' rights. And in this respect, maybe the most interesting proposal comes from this this compelling paper by Landi et al. Published in 2020 in Data Intelligence, which makes several important points regarding the pair accessibility and reusability in the context of the FAIR principles. So the starting point of this presentation is a recommendation or slogan, we could say, set out in the Horizon 2020 program guidelines on fair data, according to which data should be as open as possible and as closed as necessary. And compliance with data protection law is absolutely a necessity, not only for ensuring legal compliance, but also to foster participants' trust in the research. The authors move on by stating that there are two main ways to approach the data protection risks of data verification. One is avoidance, so the adoption of data anonymization techniques, because in the case of anonymous data, so data that have been irreversibly de-identified, data protection law does not apply. So in this case, in the case of anonymous aggregated data, access can be in fact unrestricted. However, proper data anonymization is not always technically possible, and sometimes it is not really desirable because it may reduce the utility of the data. And when it comes to the verification of non-anonymous data or personal data, compliance with data protection law is inevitable. So in this case, in the context of the accessibility principle, authentication and authorization procedures must be implemented in line with data protection law. So this means that according to the authors of this paper, fair operational metadata should be created to describe the accessibility conditions for each data set, considering all the applicable data protection and ethical and regulatory requirements. And to this end, the relevant regulatory and ethical documentation, such as informed consent forms, data sharing agreements, privacy policies, and so on, should be converted into a computable, machine-readable, and machine-actionable format that is sufficiently structured and optimized to be processed by computer, which in turn creates the conditions for the automation of access and reuse of data and efficient large-scale data visiting and the protection of data subjects' rights. The problem here is that naturally, access procedures cannot be completely automated. The assessment of some requirements, legal requirements, requires an intervention of human agents. For instance, when an entity located outside the EU or the EEA seeks access to data, and it is located in a country that is not covered by an adequacy decision by the European Commission, in this case, there is need for someone to assess on a case-by-case basis whether, for instance, adequate safeguards are in place that ensure a level of protection equivalent to that ensured in the EU or EEA, or whether other exemptions apply. This is not really something that can be left to a AI entity or a computer. So in these cases, well, given these instances where full automation is not feasible, an access committee composed of human beings is likely needed when it comes to personal data, and particularly sensitive data such as health-related or genetic data. However, the translation of the legal and ethical documentation into a machine actionable format may help automate substantial chunks of the access procedure, facilitating the exercise of rights by the data subjects, limiting the intervention of human agents only to cases in which such an intervention is really needed. But naturally, of course, for such a solution to work, some key preconditions must be satisfied. First, the duties and responsibilities of all the actors involved must be clearly allocated, such as the data protection duties and obligations under GDPR, and Kira Staunton will talk about the legal qualifications under GDPR in a minute. And secondly, clear and standard operating procedures for the submission of access requests, for the review of access requests, for the exercise of participant rights, and automatically generated DTA template must be drafted. These are the criteria that have inspired our work at EURAC regarding the CRIS biobank and platform and dynamic consent, which aims to enable an efficient processing of large-scale access requests while ensuring compliance with the ethical and legal requirements. And although it concerns a biobank with all its specificities, this experience may provide a useful case study for efforts to reconcile data verification and data protection, also in the context of the ENLIGHTENme project. Thank you for your attention.
Thank you, Andrea. Thank you very much. This was very clear and interesting. So we have some questions that did arise. So I will just pose them to you briefly, and then we can potentially discuss them later in. So While the GDPR does provide protection for the data subject due to national derogation, isn't there the risk that data subjects, research participants, will be left with very little rights and almost all decision-making left with the data controller? And this may be true also in case the data are completely anonymized. I leave this question to you first.
No, that's actually a very good point. Because when it comes to the FAIR principles, their assumption is that, their implicit assumption is that there are two points of reference. On the one hand, you have the data and metadata, and on the other hand, you have an entity, a researcher seeking access to the data. So in this picture, against this backdrop, the principles do not take into account third parties, other relevant stakeholders, such as the data subjects, with all their rights. And this has been pointed out by this really scarce, quantitatively scarce literature on the relationship between FAIR principles and data protection. And the very few scholars that address this issue point out the need for making sure that the verification process goes hand in hand with ensuring respect for data subjects' rights. So the information infrastructures that will be implemented to verify data will need to have sections and forms of communication with the data subjects to let them, to enable and empower them to effectively exercise their rights.
Very good. Thank you, Andrea. I think this discussion will go on during the panel, but I think it's worth now listening to Kira Staunton's presentation and then have a much broader picture of the legal landscape so that we can have a broader discussion on the topic. Kira, I will leave you the word.
Great, thank you, Deborah. Thank you for the introduction, and Andrea for a great first presentation. I'll also just stop sharing my video just for the purposes of the talk in case there's any internet issues. So today, as Deborah said, I'm going to talk about focus on responsibilities and who has responsibilities in the context of a consortium. And so what I'll do is I'll first look at data sharing and the different contexts in which it can occur. And then I'll just have a very brief kind of comments on how data sharing is regulated internationally, because after all, consortium are usually involved multiple parties from multiple jurisdictions that often and increasingly involve partners from outside of the EU. And then what I'll do is I'll go and turn and look at the impact of the GDPR in this domain and focus on who has responsibility for what. Okay. So there are different contexts in which data sharing and data can be shared. It can occur between individual researchers who may have a collegial relationship, a collaboration between each other, and they have kind of very informal agreements in which to share data. Data sharing can also occur through institutional agreements. Two institutions have formal agreements in place in which they are going to share data. You can also access data through biobanks, and biobanks and data banks have very much emerged as infrastructures through which data can be stored and in the future shared. Now, biobanks can vary considerably in their purpose, their governance arrangement and sample collection, but one common factor that they have is that it involves the storage and potential future uses of data. And finally, as I'm going to focus on today, data can be shared in the context of research consortia. Research consortia may exist for 5 or longer years, maybe shorter. Data may be collected and shared amongst partners with the objective of answering the research questions. Now, turning to the regulation of data sharing, Andreas began to touch on this push towards open science. and this idea of open data sharing. Well, this push very much came from the Human Genome Project, and this was the emergence of, open data sharing as quickly as possible within 24 hours. And it's now very much pushed by international funders. It's required by grants. Journals are now requiring it, and so on. And this data sharing is increasingly international. In the context of the current pandemic, we're seeing data being shared at rapid speeds across the world. Now, there is no overarching legal framework that regulates data sharing internationally or indeed nationally. And there are many reasons for this. If we look at just why there is no international framework, well, first of all, I think it's really important to note that the ability to share data, it really requires a technical infrastructure that may not always be in place. Not every country in the world has the technical ability to share data and to exploit the data. Importantly for us, there's often legal and ethical considerations in place in countries that impact the ability to share data. This will vary according to the region. Example, the GDPR is very important in the context of Europe, but there's also national legislation in place across the world in many jurisdictions that will impact upon this ability to share data. But also there are different issues arising depending on the type of data that we are referring to. For example, there may not be as many considerations for anonymous data as personal data, and so what very much context does matter. But despite all the different types of data that may be shared, metadata, anonymized data, aggregated data, what I'm going to focus on today is what we call personal data. So personal data can potentially identify a person, and how we may share that in the context of a research consortia. And in particular, I'm going to look at the obligations that arise from the General Data Protection Regulation, or the GDPR. So now looking at data sharing under the GDPR and its impact. There are a number of key individuals identified in the GDPR that are important in data sharing. There's a data subject. In the context of research, that would be the person, the research participant, we often call them, who's giving their data for research. There's the data processor and the data controller. Now here in the context of this talk, I'm not concerned about the process that happens with the data subject sharing the data with anyone involved in the research consortia, but how that data is shared once it has entered the research consortia. So research participant has engaged with the consortium, they've given their data, and I'm concerned about how you may actually go about sharing that data amongst other partners in that context. So I'm very much focused on how you may share between a data processor and a data controller, and importantly, what responsibilities each of these individuals have. And so there are two ways that you could potentially be sharing data. It could be in the context of a processor-controller relationship, or in the context of a joint controllership. Now, the responsibilities of the processor and the controller do differ. So it's incredibly important to identify who is a processor and who is the controller, and how and what is the type of relationship in which that sharing is taking place. Is it a processor-controller relationship, or is it in the context of a joint controllership? So now let us look at these individual partners. So it's the data controller. Article 4.7 says that the data controller is the individual or the entity that is determining the purpose and means of processing of personal data. So the data controller is that who is deciding both the purpose and the means of the processing of the personal data. Now, it's important to know that processing is given very much a wide definition in the GDPR. It refers to storage, collecting, sharing, very, very wide. Basically, anything that you're going to be doing with the data could potentially fall within the definition of processing. But what is the responsibilities? Well, there are a number. First, they are the person or the entity responsible for ensuring that there is compliance with the GDPR and for demonstrating compliance. If there's a breach and they're found to not be compliant, it is a data controller who is most likely to be sued. It is them who has responsibility for implementing appropriate technical and organizational measures to ensure the security of the data. It is them who's responsible for ensuring data protection by design and default. And what that means is that data protection is considered at the outset of the project. It cannot be an afterthought. So when you are considering and developing your research and your research question and your research processes, you need to, at that point, be considering, how can I ensure the integrity and the privacy and data protection of this data? It is them who has responsibilities to be met when appointing data processors. So if they appoint a data processor, who I'll go on and talk about in a minute, they need to ensure that they have the required technical expertise and the sufficient security requirements as required by the GDPR. And finally, if data is to be transferred to a third country, which is a country outside of the EU or the EEA, they need to ensure that the transfer has a lawful basis and meets the very strict requirements as set out in Chapter 5. So as you can see here, the data controller generally has a lot of responsibilities, a lot of compliance measures that need to be met, and a huge amount of responsibilities in data generally. Now, if we turn to look at research in particular, the GDPR provides for a lot of exceptions and derogations for research, and research is given very much a privileged position. Whether or not that is a good thing is somewhat subject of a debate. But as it stands, research is giving somewhat a privileged position under the GDPR. Now, the GDPR has very strict rules and principles that must be met in the processing of personal data. But it does provide for exceptions and derogations to many of these rights and principles in three ways. First, the GDPR itself introduced provisions in which there can be derogations for if on the grounds of research. For example, principle of purpose limitation, a storage limitation can potentially be derogated from, and there can be exceptions to the right to information, erasure, and right to object of the data subjects. So the GDPR itself explicitly provides for derogations for some of the principles, and it limits some of the rights potentially for the data subjects if the processing is for research purposes. Secondly, the GDPR states that member state law can also enable the processing of special categories of data that is generally prohibited if provided for law. And also certain other rights can be derogated from if it is provided by law. Now, the GDPR and potentially member state law provides for this, but it is a data controller who will decide whether or not to apply these derogations and exceptions. Now, they do need to demonstrate that the derogations and exceptions are necessary for research, and that safeguards are in place to ensure and respect for the rights and freedoms of the data subjects. But there isn't much guidance on how this will be met, and it's putting a lot of control in the hands of the data subject, or sorry, rather the data controller. So in addition to a lot of the responsibilities I've already mentioned, the data controller has a lot of control on whether or not to derogate from some of the strict protections provided by the GDPR. Equally, before I go on, they do have the responsibility for ensuring that there are safeguards. But as I said, at the moment, there's an absence of really clear guidance on this. This is very much leaving such decisions up to the data controller. So that is the data controller. Now let us look at the data processor. So the data processor processes personal data on behalf of the data controller. So the data controller decides on the means and purposes of processing, but they can appoint a data controller to process on their behalf. Now, it's important to note that a processor is someone who's external to the data controller. For example, a consultant would be external to a data controller. an employee of the data controller will not be considered to be a processor. So it's important to note that the processor is external to the controller. The GDPR requires that there is some legal act or agreement in the appointment of a data processor. So there needs to be, generally, this will be a contract in which the data processor is appointed. Often a processor is appointed because the controller themselves may lack certain expertise or technical infrastructure to meet the objectives of the processing. And because often the processors has this extra technical expertise, they may be making some decisions themselves. So there can be confusion that, well, is that like, are they deciding the means and the purposes of processing, or are they really a processor? What's important to remember is that the controller decides on the essential means. The processor may decide how to achieve, how to get there, but the controller is the one who's deciding on the essential means. Before I move on, I think it's also worth mentioning that there is a possibility of a sub-processor. So the controller will have appointed a processor to achieve a certain aim, but they've also would have asked them to go and get another person to achieve, help in achieving the same, and therefore a sub-processor relationship will have arise. So while the GDPR puts a considerable responsibility in the hands of the data controller, it's important to note that the processor itself does have certain responsibilities. And there are two types of responsibilities. What I call responsibilities generally within the GDPR. They have responsibility to maintain a record of all categories of data processing. They must ensure that they meet the security requirements as set out in Article 2, similar to that of the data controller. And the data controller needs to appoint a DPO in certain circumstances, and this will equally apply to the data controller. And all the rules on data transfers apply to the data controller. They also have responsibilities with the data controller. Both the data controller and processor have a joint responsibility to ensure that their relationship is bound by a legal act or contract. And in the event of non-compliance with the GDPR, both of them may be fined. However, most rights most responsibilities rather reside with that of the data processor. So if data is to be shared in a controller-processor relationship, it is essential that you identify the parties, identify if it's who is the controller and who is the processor, and ensure that there's a legal act or agreement which sets out this relationship. The processor must follow the instructions of the data controller, and this should be set out. What is expected of the data processor must be set out in the contract. If the processor does not follow the instructions of the data controller and starts to act on their own, they will no longer be considered to be a processor, but will in fact be considered to be a controller. But as I said, most responsibilities reside with that of the data controller. So that is a controller-processor relationship. A person has decided in a research consortia or in a research project has decided what is the aims of the research and how they're going to achieve that, but they need some technical expertise or other expertise, and they appoint a processor to help them achieve the aims of the research. But increasingly, health research is collaborative, and it really involves more than one party developing a protocol and conducting a research. This is often how we have consortium developed. So as part of this, decisions will be made on the means and purpose of the processing of the data to achieve the objectives of the research. So in such a scenario, more than one body or an individual is deciding on the means and purposes of processing of the personal data. And so arguably both would be data controller. Well, the GDPR does make provisions for this through joint controllerships. And a joint controllership arises where two or more, so it envisages multiple parties, so two or more parties jointly determine the purpose and means of the processing. Now, it can arise in two ways. First, through what is known as a common decision. And this is kind of more the easier and more straightforward. The two or more parties come together and together to decide the means and purposes of the processing. But it can also come through what is known as a converging decision. And this is when decisions on the purpose and means of the processing of the parties complement each other and have a tangible impact on the purposes and means of the processing. What is important here to consider is that the decisions are inextricably linked together. And in such a situation, a joint controllership can arise. Well, what are the responsibilities in a joint controllership? It's important that in a joint controllership, the responsibilities for compliance are decided in advance of the research. They can be portioned out. Party A will ensure compliance for certain duties on the GDPR. Party B can decide for certain compliance. What's important is that together, all compliance are met. But the data subject can exercise their rights over each of the controllers. Now, there is no requirement that a joint controllership is set out in a legal act or agreement, but it would really be strongly advisable that this is done so, and arguably important for me the principles of accountability under the GDPR. But now, turning to a joint controllership in research. Well, a joint controllership can arise in research where the entities jointly decide on a research question and a means through which they will answer that research question. But a joint controllership can also arise for two or more parties at processing data for a commonly defined research purpose if the processing is complementary and that the research would not be possible without the involvement of all parties. Now, interestingly, the guidance from the EDPB is that the parties do not have to be involved at all stages of the processing or indeed have access to the personal data. What is key is whether they are looking at the processing activities of each party has an intangible impact on the research question and how it is to be answered. And the EDPB has stressed that what is important is that you look at the practicalities and realities of the processing in the context in which it occurs. Now, answering this question may not be straightforward and often is not straightforward. But the EDPB has provided two examples, which I think is important to give in this context. One, in the context of the use of a platform, so different partners may use a platform, a standardized tool, or other infrastructure that has been developed or hosted by one partner. So in this scenario, the EDPB has stressed that if several institutions work on a joint project that feeds data into an infrastructure held by one partner in the research project, all institutes qualify as joint controllers for the data processing on the platform, as they have decided on the means and purpose of the processing. Now, for any data processing outside of the data processing, they are separate data controllers. And second, in the context of clinical trial, the EDPB has provided two different scenarios that can help illustrate how to identify the different parties in the context of a clinical trial. So if we have a healthcare provider, which is the investigator, deciding jointly with the university, who could be the sponsor, to draft a research protocol with the purpose of a clinical trial, they are joint controllers. Now, the healthcare provider will remain the controller over data for clinical care, but they will be in a joint controllership with the university for the processing of that same data in the context of research. But if the hospital is not involved in the design of the clinical trial and accepts the protocol as designed by the sponsor, the hospital is the processor and the university the controller. So what here is important, we see is important, is involvement in protocol development. So just to conclude with some recommendations, in the context of consortium and establishing a consortium, it is essential that you identify all the parties who are going to be involved in accessing and sharing data. Then you need to identify the roles. Are they going to be processor or controller? And then it's important to identify the basis and relationship in which they're shared. Is it one which is going to be in the context of a joint controllership, or is it in a processor controller relationship? Thank you.
Thank you very much, Shakira, for this super clear presentation. Yeah, I think this was very much needed. So I have a question for you. Do you think that in this condition in which the controller has most of the responsibility, we could really see different right provisions in different countries where...
Yeah, 100%. And this is a problem. Depending on who's the controller is going to, and where they're located, and because of the derogations for research, is going to impact what rights and responsibilities a data subject has, which is hugely problematic. Something I didn't have time to get into, but yeah, something that is problematic.
So does this really mean that you will have different rights as a data subject in the UK? Well, in the UK, probably yes, but like in the Netherlands, let's say, or in Italy?
Yeah, because the protection for research and genetic data in Italy and also Ireland, for example, there are lots of rights and protection on, particularly on the use of genetic data, but they aren't in place in the others. So your rights and your protections very much apply according to where you're based.
So
bring it in this, so it's, as a result, it's brought in this more fragmentation, despite the fact that the purpose of the GDPR was to introduce this harmonized approach to how we protect our rights. So it is, even in the identification, which I didn't have time to get into, so not only do you have to identify who's controller, the processor, all of these other issues of where the data is coming from, where they're shared, these national rules really need to come into play, showing the importance of really knowing the national law as well as the overarching regulatory framework from the GDPR.
So I will open the floor for like a 15 minutes general discussion on the legal aspects. So if you have some questions, I mean, you can just intervene or write in the chat. In the meanwhile, I have a general question for both speakers. So we know that we're talking about personalized data within the GDPR and most of the regulations. But what happens with data that are not personal data and still collected within the framework of research? Are they subject to other rules, or are those data like out in the wild and can be used for any further use that goes outside the scope of the research, and maybe for uses that the donor never foresaw or never wanted to be pursued?
Potentially, yes, because there isn't the same legal protection of non-personal data. Now, we do have the ethical frameworks that are in place, which one can fall back on, but they lack the force of law, which would be problematic. So we're seeing this split between ethical principles and legal protections. Personally, I think there's been so much focus, and rightly so, on protection of personal data. But as a result, it's been forgotten all of the other issues that are arising in the sharing of data generally. There's always been too much focus on this to the detriment of other issues that we should be looking at in the context of data sharing. I don't know, Andrea, if you have any thoughts?
You know, I was thinking about the role of the increasing popularity of the FAIR principles. In particular, I'm thinking about the pair of other principles, because in my presentation I focused on the pair accessibility and reusability, but there is also the other pair, findability and interoperability, which, if fully implemented, may create more conditions for extensive data linkage, and which may help the re-identification of individuals. So if verification goes well and is implemented widely, this may result in data that now we consider non-personal data being actually becoming, again, personal data, which at the same time is not necessarily a bad thing, because if data qualifies personal data, then all the protections provided for personal data apply. So it is a bit this.
Depending on the nation where you are.
Yeah, of course.
But I think we really need to start having, particularly with all of this discussion in COVID and the importance of data sharing for this aloof, ill-described, ill-defined public interest. I think there needs to be a wider discussion on what data we're talking about, what rules and principles should apply to the different types of data, because context really, really is important, and the type of data that we're talking about is important. Of course, there's a lot of risks associated with the sharing and onward sharing of personal data. But I may still, as a data subject, have opinions on what and who and why and in what conditions I want my data accessed and used. Do I really want my data shared widely with a company who's going to make huge profits for themselves and their shareholders, not necessarily have a public benefit? Probably not, but I would be more happy to share my data, whether or not I personally or not, with a researcher who is going to achieve a public health benefit. So I think there just needs to be a much wider conversation on the different types of data and what should apply to these.
Andrea, Kira, for both of you, you just mentioned the notion of public interest. Could you elaborate a little bit on that, and why is this concept so important and how it is perceived?
I think it's important for a number of reasons. One, it's mentioned in GDPR, and it's a grounds in which you can share data. Now, its public interest needs to be defined in national law, but that very much depends on the individual countries. It also, if you apply public interest ground, the data subject loses a lot of rights and protections that they would normally have. A second reason, I think, it's been completely exploited. The term has been completely exploited, particularly in the context of the COVID pandemic, saying that if it's in the public interest or this collective interest that has not been defined, therefore it's okay for us to share and use the data. For example, we were encouraged to share data in the context of COVID pandemic. People got on board, we needed therapies, we needed vaccines, but we're realizing it's not been a public benefit. There's been a national benefit in certain jurisdictions, but there has not been this global public benefit. So they're the two thought areas that I think is important.
Yeah, the public interest may be exploited, and this being exploited in this way. I was thinking about the fact that when the public interest is invoked, the GDPR also invokes some constraints, such as the principles of necessity, proportionality, that may, if duly considered, may help tackle from a legal perspective the risks of abusing public interest in this context. But
the problem with that is that it's if the ground is there, it's the data controller who's giving the power to decide whether or not to apply it and invoke it. And so while there are these principles, it is still being very much left to the data controller. And unless the data subject takes a case, and they have to be aware that their data is being processing, and often they aren't aware of it, so they can't invoke these rights that they do have. And so therefore it kind of makes this, you know, we're ended up in a situation where the data subjects are left with essentially no rights if all of these principles or if public interest is invoked.
Mm-hmm. So, I mean, I know you worked extensively on oversight mechanism that should actually be implemented for this type of use that is also foreseen in the GDPR. Could you tell us a little bit about this?
Well, I think there needs to be a couple of different oversight mechanisms. There certainly needs to be one for each individual research project, irrespective of where they're getting the data. There needs to be ethical oversight. This doesn't happen in every country, and sometimes there's this leaving the data, and if that ethical oversight does not happen, again, it puts a huge amount of control in the hands of the data controller, because it's them who decide on the reuse and the research projects and the reuse of that data. Really, we need to have much stronger national frameworks in place for the use of data, and get away from this assumption that research is inherently good and that all research as it happens is inherently good. Research can be discriminatory, can be destigmatizing, and we cannot have the assumption that data subjects, once they give their data to an individual, that they're happy for it to be reused indefinitely. But I think the time really has come for a more global conversation on how we regulate and oversee and who has responsibility for enforcing rights for the data subject, because it's their voice that's very much left out of this conversation on data sharing.
Thank you. Are there other questions that we want to address for this specific session? I have one, because I think that the discussion we had, and we have Mike on board, could be useful to the wider audience of PIs of the ENLIGHTENme project. And I want to ask the speakers if they would be available for a webinar potentially with the PIs, because I really think that having this discussion, explaining why some of the provisions we are developing for the project are necessary, can help understand and accept some of what is often perceived as burden coming from the legal world. I would then say that we can take a break now before going further to the next two presentations, and we can reconvene at 11:10 and start with two other presentations, which are more focused on the ethical aspects, I would say, of the research we are doing, and having a final discussion all together at the end of the two presentations. Have a nice coffee break.
Thank you.
Thank you. Thank you, Deborah.
Ciao, Giulia. Okay, I think we can slowly introduce the discussion back. The next two presentations will be more focused on the ethical aspects of research. Elisabetta Pulice will now introduce the concept of research integrity and how this is applicable also to our consortium and the work in ENLIGHTENme. And then we will see a more theoretical approach to justice and urban lightning presented by Mirko. So I leave the word and the floor to Elisabetta.
Good morning. Thank you, Deborah, and thank you, Andrea and Kira, for your presentations. Let me share the screen. 1 second, and the presentation. Okay. We should see it now.
Yes.
Okay. So I'm really, let me also stop the video because.
Yes.
1 second. Oh, I cannot find.
You can also leave the video on if you like. It's not an issue.
Okay, but it was just for be sure.
Okay.
For internet issues.
Sure, sure.
Okay, so I'm really glad to discuss with you the role of research integrity in enhancing the quality of research and in protecting fundamental rights. And I would like to start by discussing with you why are we talking about fair data principles and accountability, responsibilities, as my colleagues did, and why we will discuss about justice. All these aspects are related to research integrity, and to answer to this question, why to care about research integrity, we should start from the questions that you can see, since research integrity means conducting research in a way that allows others to have confidence, trust in the methods and in the findings of the research. And research integrity relates both to the scientific integrity of the research that has been conducted and to the professional integrity of researchers. the need for research integrity is also linked to the role of science and research, and in particular to the link between research integrity, high quality research, and economic and societal advancement that has been acknowledged worldwide. But research is also associated with improvements in living standard, health and well-being, advancement in human knowledge. But it's another issue that is important to stress is the role of public investment in research. And public investment is usually linked to a wider policy and to specific objectives. For instance, in the public investment in European research, the objectives are to ensure that Europe can address its economic and societal challenges in a proper way, can create high-skilled employment based on research-driven innovation, and so on. So the importance of high quality of research. Moreover, research findings are used to inform public policy and to inform future research. So in this context, the reliability of knowledge and its preservation are becoming more and more crucial, especially when the research activity is highly collaborative, interdisciplinary, as it is the case of the ENLIGHTENme project. And integrity of research findings is based on the assumption that the knowledge presented is true, complete, and unbiased by economic, political, or ideological influences. And that is the reason why, that's why research integrity is at the core of science and scholarship, but is also the basis for researchers to trust in each other, as well as to trust in research record, and is also the basis of society's trust in the research system. And this issue is also related to the role played by research integrity in dealing with a balance between research autonomy and responsibility, and in balancing values and interests that might be conflicting. On the one hand, we have participants and patients' rights, or parents if you are dealing with minors, the protection of society or public interests, protection of vulnerable groups, and then on the other hand, research interest, scientific developments, the interests related to linked to founders, sponsors, the careers of the researchers. And I mean, as you can see, sometimes it's difficult to draw a line between these two aspects, but in any case, it is important to find a proper balance between them. So what is research integrity then? First of all, there is not a universally accepted definition of research integrity. We have many national, international, but also European documents that are similar in the intent, but they are not identical in their content. Usually, key elements of research integrity include these values that you can see: honesty, rigor, transparency, open communication, the care and respect of all participants, accountability, reliability. And research misconduct is traditionally defined as fabrication, falsification, or plagiarism, the so-called FFP categorization, in proposing, performing, or reviewing research, but also in reporting research results. But apart from these key elements and deep definitions, there is a variation in the principles that are considered to be inherent to or correlate with these values. There are also differences as to further violations of good research practice that damage research integrity, and there are also differences in sanctions and the procedures. Usually these documents are also considered to be living documents, and I will come back on it. As we know, the link between high quality standards of research and research integrity is gaining growing attention also at European level, especially for EU-funded projects. At the European level, ethics and integrity are considered for all funded projects from the beginning to the end. The connection between research ethics and fundamental rights is stressed, and awareness of the impact of research, as well as the impact of research on society and fundamental rights, as well as compliance with the relevant EU regulations, code of conduct, international conventions, and so on are the major aims of this attention. And this is particularly important in research projects, including health studies. As researchers, as we already know, in addition to the ethics self-assessment, we must confirm compliance with the European Code of Conduct for Research Integrity that is published by the European Federation of Academies and Sciences and Humanities. And according to this code, good research practices are based on fundamental principles of research integrity. And research integrity, these principles guide researchers in their work as well as in their engagement with the practical, ethical, and intellectual challenges of research. And you can see reliability, honesty, respect, accountability, and these elements should be present at all stages of research in the design, methodology, communication, review, and the developing of research, and in the relationships with colleagues, with participants, society, publication, and so on. And indeed, these are the context in which the code provides more expansive definitions of the principles of research integrity. And as I told you, as I already said, the code is a living document and will be periodically reviewed and revised as necessary. And why? To take account of evolving concerns, because the code is aimed at serving the research community as a framework for good research practice. And one of the major challenges of research integrity is, as I said, the balance between autonomy and responsibility, between research interest and fundamental rights. So research integrity is not only aimed at to limit, but also to promote high quality of research. And the revision is motivated by developments in different fields affecting research activities, such as research funding, regulatory landscape, institutional responsibilities, communication, use of social media, the citizen involvement in research, and so on. These are further examples of networks, foundations, associations that elaborate standards, codes, guidelines, and statements on research integrity. And this is a summary of the main principles of research integrity, which, as you can see, is traditionally intended as a body of principles of ethical values, professional standards that form the basis of the responsible and correct, you can see all the principles, conduct of not only of those who carry out research, but also of those who finance the research, evaluate scientific research, as well as the institutions that promote and perform research. But are we dealing with legal or ethical principles? Well, although, as already said, there are several concepts and definitions of research integrity. Sorry, are you? Sorry. Are you see the right screen now?
Yes, we do. Not
now.
Sorry. I don't know why. Just 1 second. Nothing?
No. Choose the screen. Okay, now. Now.
Okay, you see the presentation and in the right version, only the presentation.
Yes.
Okay. Thank you, because I don't know why I couldn't see it anymore. So sorry. Okay, we were here. As I was said, I mean, although there are several concepts and definition of research integrity usually lies at the intersection between different disciplines, and namely science, ethics, and law. So it means that on the one hand that we have specificity of terms, of needs, of the understanding of a given principle, which might differ from a scientific field to another. But on the other hand, it means that we need dialogue between these disciplines, especially in interdisciplinary research project-wise, such as these projects, such as ENLIGHTENme. Moreover, in this presentation, I'm not dealing with just general principle of research integrity, but with codified principle of research integrity that are codified by the research community itself, research centers, institutions, university, and by public entities protecting, promoting, and funding research. So from this perspective, research integrity is characterized by a plurality of sources and authorities. First of all, we have different regulatory levels, the constitutional, the international principles, the Convention of Human Rights and Biomedicine, European Convention of Human Rights. Informed consent is one of the basic principles in many international documents. EU sources of law, the GDPR, we have already told about that, but also regulations of medical trials and so on, then national and regional regulations, but also specific regulations that for different research fields, such as biobanks, genetic data, and so on. For these sanctions, for these sources of law, we have sanctions, but then we have also, in addition to these sources of hard law, there are also regulatory sources dealing specifically with research integrity, code of conduct, rules of professional ethics, guidelines, good practice, professional standards, and so on. So as a consequence, principles that are important for research integrity are embedded in sources of hard law. Plagiarism, for instance, as we have one of the aspects of misconduct, GDPR, informed consent, but further principles are embedded in the mentioned sources of research integrity, and we have already seen some of the basic principles, honesty, respect, and so on. There are also principles embedded in both types of sources, either directly. For instance, plagiarism and informed consent are regulated in both types of sources, or indirectly, for instance, through the reference to legal sources of law, references that is made by code of conduct. Different regulatory levels may also mean multiple liabilities, because we can have criminal liability, civil liability, but also disciplinary liability for breaches of code of conduct, for instance. Moreover, on the one hand, breaches of legal rules, GDPR, rules on plagiarism and so on, become violation of principle of research integrity, because research integrity means also, as we have seen, compliance with the legal rules. And on the other hand, it means that sources of research integrity complement legal rules with further principles and duties. But if we already have GDPR, criminal, legal rules, and so on, what is the possible added value of sources dealing specifically with research integrity? Trust we have already seen, but moreover, code of conducts that are developed by the research community can take into account its values, needs, expectations, difficulties, pressures, thus helping in find a proper balance between autonomy and responsibility in a more flexible way. And I want also to stress the sense of belonging to a research community, research institution, research university, which means at the same time protection and responsibility. If we provide information to participants, the logo of the research center of the institution on the information sheet, or the name of the institution on a publication, create trust quickly. But as researchers, we must be responsible toward both the participants and the institutions. In any case, it is important to stress once again that the aims of research integrity are twofold. On the one hand, research integrity regulates research, limits research activities in order to safeguard, of course, fundamental rights. But on the other hand, research integrity is aimed at promoting research, funding research, and enhancing the quality of research. Furthermore, similarly to other professional regulations, research integrity always concerns two different but interconnected dimensions of research regulation, the internal and external to the research community. The first one, the internal dimension, concerns the relationships among researchers and includes sharing of research results and dissemination among, of course, many other contexts. The second one is aimed at protecting participants and society or other public interests, such as preventing adverse impact on the environment, waste of resources, and so on. And the research conducted in the ENLIGHTENme project plays an important role in increasing public awareness of the impact of urban lighting on health and well-being, especially for vulnerable populations, but also of the role of urban lighting in shaping urban spaces and social life, and also the risk of inequality. So it must be promoted and enhanced for this role, but at the same time must be compliant with these ethics and legal principles that are common to the EU-founded projects: human dignity and integrity, in the free and informed consent, protection of vulnerable persons, privacy and confidentiality, justice and inclusiveness, minimize harm and maximizing benefits, share benefits, and respect and protect the environment and future generations, including future generations of researchers. And there are just some examples of how to translate the mentioned principles of research integrity and the combination of internal and external dimension of research integrity into practice. To protect participants in health studies, but also in social or anthropological analysis, we should consider the multi-level protection of their fundamental rights. So as already said, international, European, national fundamental principles, the example is informed consent, but also code of conduct of the institutions, honesty, transparency, fairness, no false hope, for instance, also are other principles that protect participants. In health studies, the codes of medical ethics, if the researcher is also a medical doctor, and then specific regulation, we have already seen the GDPR, but also regulations for vulnerable people and stigmatization, and against stigmatizations. Principles regulating the relationships among the research community are mainly linked to the FAIR principles that we have seen, but also again, transparency, respect, honesty with colleagues in reporting the results of research, and then research misconduct to avoid research misconduct, and publication, authorship, and so on. And openness in research is more than just access to research. Of course, it brings also equality to the research process. And obviously, these principles have an influence also outside the research community because they affect many public interests. And they are certainly linked to the social responsibility of research and its social impact. And researchers must maintain scientific integrity and respect the principles of research integrity to ensure that the result they produce are reliable and can be used with trust, with confidence by the society. And it's also the society that funds researchers. And the fabrication, falsification, plagiarism are not just dishonest behaviors, but they also compromise the integrity of research, of science and research itself, and they may have a negative impact on future research endeavor, and the result is a waste of resources and the damage to public trust. Social and scientific relevance of research, as well as the role of communication, must also be stressed. So that these are the reasons why in a project like the ENLIGHTENme, it is important to have a data management plan that is also considered by the European Union, the Commission, to be a living document to clarify how data produced and or used in the project will be collected, stored, accessed, or shared, and also the fair data principles. It also to clarify long-term exploitation and conditions for use, and then to demonstrate compliance with the specific ethical and legal requirements, which are usually described in deliverables, and namely procedures and criteria that would be used to recruit research participants, informed consent procedures for both participation and data processing, measures to protect vulnerable people, minimize the risk of stigmatization, and then all the other principles and technical and organizational measures to safeguard participants' rights, security measures, and so on. To conclude, I'd like to mention some of the consequences of the violation of research integrity. Of course, sanctions, including discipline, the disciplinary sanctions, but for breaches, as I said, of code of conduct, and this I have already stressed this multiple liability. Ethical approval can be denied, or a funding request can be rejected, but it can also be financial or societal cost in case of misconduct. And there is an example of a study I conducted in the US in 2014 of publications retracted because of serious misconduct, which analyzed two important effects associated with research misconduct: financial cost to funding agencies and damage to the research careers of the researchers. But these articles stressed this is probably one of the greatest cost of misconduct: preventable illness, or even the loss of human life due to misinformation in the medical literature. In this case, it was not directly assessed as a cost, the last one, but has also been stressed, and I think it is important. So, taking into account all these factors, these are the 7 reasons to care about research integrity according to Science Europe, and you can see how research integrity safeguards the foundation of science and scholarship, public confidence, research evidence, public investments, reputation and careers of researchers, prevents adverse impact on passions on the public, promotes economic advancements, prevents avoidable waste of researchers, and importantly, according to the European Code of Research Integrity, every effort, in addition to the sanctions, and even more important than sanctions, every effort to prevent, discourage, and stop violations must be done, and how using these tools, training, supervision, mentoring, development of a positive and supportive research environment. And researchers, all these bodies and actors, researchers, academies, societies, funding agencies, organizations, publishers, and so on, each have specific responsibilities to observe and promote these practices, the good practices of research and the principles of research integrity. And thus, to conclude, this is the last one. Since we all are included, since we all are responsible, I like to share with you this application, this dilemma game app made by the Erasmus University of Rotterdam, and to simulate awareness and critical discussion about integrity between among researchers using this app, using this game. Thank you.
Thank you so much, Elisabetta. This was very thought-provoking. So I would open the floor for some questions if there are some burning issues. Otherwise, we will continue the discussion after Mirko's presentation. In the meanwhile, I have a question for you. What do you think is the most effective way to promote research integrity within, for instance, a consortium like ours?
Actually, you answered to this question before by asking to Kira and Andrea if we can have a dialogue together. I mean, in an interdisciplinary consortium, it is important to, I mean, dialogue between disciplines is important to understand the rationale of rules and to accept them. So then in general, training on research integrity is important. Information and training and discussion. These, I think, are important tools. And but I mean, for instance, as lawyers, I mean, we have also a responsibility in letting researcher understand why the reason why to care about a rule, what the importance of a rule of ethics or legal requirement.
Mm-hmm.
And try to understand the reason of researchers and try to find a balance. But I mean, I think that, I mean, while studying this topic, what is clear by now is that there is not enough awareness and knowledge about research integrity, about these principles. So that's why training and dialogue and occasions to discuss together are important.
So I can see there is a question by Mirko. So he says, so far Retraction Watch counts more than 200 COVID-related papers that have been retracted. The duration is from July 2000 to August 2021. Do you think that this will affect public trust in science? Or is the retraction actually showing that the system works?
This is a matter of communication. It's a matter of how it is communicated. I mean, the problem of communication in science is very important, and it may mean that the system is functioning, but you must explain to the people, to the society in a correct way. Otherwise, might be misunderstandings.
Okay.
So, as research, we should also work on communication. I don't think what you're.
Thank you, Elisabetta. I think that we will now hear Mirko's presentation. Mirko Ancilotti will present on justice and urban lightning. And after his presentation, we will continue our conversation on that topics. Please, Mirko.
Okay, thank you very much. I will now start sharing my screen, hopefully without tragedies happening. Let's see. Please can confirm me that I'm sharing.
You are.
Thank you very much. Okay. So, hello everybody, I'm Mirko Ancilotti. I will introduce myself and my work and then go on with the presentation of the work itself. I am a postdoc researcher at Uppsala University in Sweden. My background is in philosophy and I have a PhD in medical sciences, mostly focusing on public health and bioethics. And I am involved in ENLIGHTENme, working together with Deborah Mascalzoni on the ethics of urban lighting, the ethical aspects for the most part. This is an overview of what we will go through together. So yes, what I've just done, the introduction to this, and then methods and materials, because this presentation is heavily based on empirical work. Basically, we did a well, I would call it a synopsis, just not to be too arrogant, but it is actually a systematic review of the ethics and morals papers, the ethical literature about light pollution, light urban lighting, domestic lighting, and all these related contents. And I will present those that I identified as two dominant frameworks, the one about human vision, the one that I dubbed extensionist framework, and then a couple of humble proposals about ways to proceed with not for the entire academic debate on the topic, but with our work, using more and more the concept of environmental justice, and also looking at the One Health approach to urban lighting, which is, although yesterday was mentioned by Professor Kimball, but is relatively underexplored in the field of urban lighting. As I said, I performed a review of the academic literature, and I will say that it is a systematic review, but the results are so scarce that it's hard to call it a systematic review, and also because the aim has never been to publish it as such. Anyways, just to give you a context, I performed this search in 5 databases: the Web of Science, Scopus, Field Papers, PubMed, and JSTOR, which I believe are relevant databases for this type of research. A huge time span from 71 to 2021. And I've been looking for, well, basically two major contents: the morals and ethics from a part, and a long list of lighting related terms like nighttime lighting, urban lighting, outdoor lighting, light pollution, lighting quality, and so forth, that I had found in the literature that I was already familiar with. The search only produced 44 hits, and after getting rid of duplicates and stuff that were not, contents that were not really relevant, we ended up with only 14 results. Of these, about half were focused on the focus of these works, of these studies, was exactly the ethics of lighting. But in the other half of papers, this was a secondary and ancillary content that the authors passed on or passed by, but not exactly their focus, let's say. Yes, I will then tell you about the state of this ethical debate in the next slides, and then about the future direction that we will take within the project as well, from the ethics part. The light pollution is the dominant framework when we talk about lighting, artificial lighting mostly, of course. And this has been essentially conceived negatively, I mean in pejorative terms. And this notion of light pollution has become the common way to conceive the concern over excessive or obtrusive artificial light. Now, I think it's important to mention the fact that this is a framework, because as all frameworks, also this one tends to set the limits within which the topic is discussed. And essentially, it has been framed as an environmental issue. And that's something that is relevant for us to keep in mind. Urban nighttime lighting, artificial urban nighttime lighting, can be considered, can be held as the major cause for this framing. As noted by Taylor Stone, who is one of the most proficient authors in the field, this notion, we shouldn't fight it. It's okay to use it, but just we should be aware of the fact that we can move within the limits of what this framework make available for us, sometimes trying to dig to reach a new depth within the framework, or try to lose a bit those that we have to understand as boundaries that are set by thinking about the issue of urban lighting as mostly as light pollution. That is, or at least from an ethical debate, I mean, it has been framed this way by most authors. So this framework helps us to assess the conditions under which and the parameters to measure when there is too much light. So it's good, it's useful, but it also sets the limit of the discussion. And the fact that it is mostly framed as an environmental problem is probably due to when we became fully aware, at least in the modern era, of the problem. It raised in the 70s, and it was raised by mostly astronomers that were whose work or whose hobbies, so looking at sky at night, was hindered by the presence of too much light. Yes, we can, and yeah, I call this the framework one, the human vision, because mostly the problem is connected to the fact that it is a problem for what we want to see, or for, in general, for human vision. The light pollution as a negative or undecided nighttime lighting under the framework of human vision can be categorized as follows, and this is a very, very common type of categorization for this problem. It can be categorized as sky glow, which is the diffuse luminance of the night sky, so the fact that you basically can't see sometimes the moon, or in general the sky, the stars and the planets at night. Can be it is defined as a glare, the uncomfortably bright light that we the sensation that we can feel at night. The light trespass, which is when artificial light is projected into areas, into places where it's supposed not to be, where it is not wanted. For instance, in your bedroom at night, when you get too much light from outdoors. And clutter, that, for instance, this picture we have in the slide is and maybe consider an instance of when there is an excessive groupings of lights. So all these are negative aspects that are intrinsic to nighttime lighting and that affect human vision. As I said, I think it is important to remember that this has been mostly considered and shaped as an environmental problem, because in the 70s there was a strong awareness of pollution, of the problem that we were causing to the planet, and this became this anti-waste paradigm, this type of communication entered also into the issue of in the discussion of nighttime lighting. The first, from an environmental point of view, from environmental ethics point of view, the first thought is that light as a pollutant is a very peculiar type of pollutant, because in a relatively to other forms of the other pollutants, in relatively short time, it can just disappear if we consider it per se. The problems that the excessive production of light produces and the pollution that are connected to that do not disappear just switching off the lights. But per se, light, yes, is a strange type of pollutant, which may not even qualify exactly as a pollutant per se. Now, this is a schematic representation of, well, the most relevant, most influential theories and movements in environmental ethics. On the right-hand side, in colored in blue, you can see the so-called extensionist theories dominated by the anthropocentrism, and then there are the others. On the left side, there are the let's say the ecological or radical ecology approaches to environmental ethics. The label of extensionist has been given by the ecological theories to the other theories, because what they claim is that these type of theories, the blue ones, always tend to reproduce the anthropocentric paradigm, which means try to understand who is valuable, who has a moral status or a moral value, set criteria to say who matters, and then do, for instance, design urban lighting policies, design urban lights for the sake of those who are important, for those who matter. And if you just apply a hardcore anthropocentric approach, who matters is human beings, and we design lights and we enforce and promote policies that are good for us. Or we can consider, for instance, through pathocentrism or biocentrism, other entities other than ourselves, because they also matter. Now, the critique from the ecological side to the extension side is that the problem with this type of setting criteria and extending the circle of those who matter is that whenever conflicts, interest conflicts between different species, between different entities, all in all, we always prevail. The interests of human beings, for instance, what we like when we light our cities or the links between them, prevail upon the interests that we can assume that would promote that animals or interests of ecosystems and so forth. The ecological side, I can't spend too much time on them, but I can just say that they work on a different way. What they say is that we should just get rid of the anthropocentric paradigm, put the environment in the center, and change a lot about the way our societies and our structures, economic structures mainly, work. Applying ecological environmental ethics to urban lighting would imply something strongly different from what we know today. Yes, this is an a visualization, let's say, of how extensionism works. Either we care for, let's say, human beings, or we also care for human beings that will come from the future generations, or we also include the protection of, and therefore, in the case of urban lighting, will be how we design the lights in our cities for the sake of the animals, that not only those that live in the cities, but those that will be affected by how we light cities and the links and so on. Or we also include all living things, or fauna and flora at all species and ecosystems. The problem is that the conflict of interest when we have different interests from the other animals. That's why the ecological side of the environmental ethics tree call for something revolutionary, for putting the environment at the center. And that will not be, how to say, against our interests, if we believe that we are part of the environment. The second frame is exactly what I've just explained so far, is the extensionist. So just a second, I see that there's something in the chat.
No, it's a question for later, don't worry.
Okay, sorry. I shouldn't have gone there. Well, in the synopsis of the ethical literature that we performed, we found that some authors, there is not much there, as I said, have applied a kind of extensionism to understand for whose sake we should design urban lighting, for whose sake we should do policies, and what kind of consideration we should include in these policies, of course, also from an ethical point of view. And I've been able to identify 5 clusters of ethical concern: the loss of darkness, the energy waste, the ecology problem per se, and in a limited manner, in the sense that there is very, very little in the literature, the ethical concern for animal harm and for human health, or for harm to human health, of course. Now I will go through this one by one. The loss of darkness has been mostly framed in negative terms, and in this case I don't mean in pejorative terms. I mean that it has been understood by deprivation, what we are losing. Indeed, we talk about loss of darkness. And this is a rather risky way of understanding it, because there is I don't know how it is exactly called, what is the label, but there is an underlying bias here, in the sense that not everyone can understand what we are losing. My son is 5, and so far he has never really seen an unaffected night sky. He doesn't know, basically. He thinks that at night you can see the moon and 3, 4, 5 stars that we can see from where we live. And that's the sky. If you frame it as loss of darkness, it's difficult to understand for people that have never really experienced this darkness, what we're losing. Following the, and this is a point that was made by an author that I've already mentioned before, Taylor Stone. It has worked a lot on this. And he proposed to think about what are the values of darkness in order to understand better what we are going to lose. So define better what is going to be lost through positive framing of what actually is darkness and what it brings about. And it says that dark nights are valuable because they hold transformative power, so that capacity to change into something positive, the darkness itself, that change something into something positive, something else that is positive, and transformative power in terms of intellectual power, cultural power, aesthetic power, and the positive, obviously, restorative effects of darkness. While intellectual, cultural, and aesthetic have their counterparts in bright nights, in the sense that if it is true that we are losing something from the tradition, something that is intellectually linked to darkness, that is aesthetically connected to darkness, so the how that we can feel looking at sky at night, we are also gaining something, in the sense that there are beautiful installations that you can do and beautiful things that you can do through lights, or even during the night. It can promote cultural contents in cities, in neighborhoods, and it brings together, of course, also brings along also intellectual contents, new contents that are not connected to darkness. But for sure, with heavily illuminated nights in the cities, we don't have the restorative effects of darkness, and that's a very important loss. So yes, the other important ethical cluster is the one of energy waste, which entails it is consisting in unjustified overproduction of energy for lighting purposes, with consequent detrimental effects on the environment, and so pollution that is caused by the energy production, and the allocation of public economic resources, because if they are located in lighting of cities and links between them in an overabundant way, then we are not using this money for something else that might be more, where they might be more useful. But it is difficult to understand what is the threshold, how to weight between the proper use, what is proper use and what is actually waste. And that's a matter of criteria. and for instance, for whom this is a proper use and for whom this is a waste. We come back to the extensionist way of thinking, like for whom this is a proper use. Here we talk about ecological concern, and that this encompasses both the issue of the harm provoked to fauna and flora, by the intrinsic negative effects of nighttime lighting, but also the environmental issue connected to pollution caused by the energy required for nighttime lighting. And the intrinsic negative effects of nighttime lighting are, for instance, the changes in behavioral patterns, reproductive patterns of wildlife, and then the problem of energy production per se, that is air pollution, water pollution, the climate consequences of that all this provoke, in general can be encapsulated as can be seen altogether as a problem for biodiversity. And I think that Kimberly Deal, that is another researcher working in the field, I can just read this quote here. We have at least one indirect reason to conserve dark nights. Natural darkness is, after all, integral to the health and the reproductive success of biodiverse ecosystems and their constituents. I think that I find its simplicity powerful. There is very little in the literature about the animal harm and the connection with in the ethical literature about animal harm and lights. While the example on the left is very complex and is not exactly connected to urban lighting, the example on the left is what I want to convey with this image is that, for instance, hens are subjected to altered cycles, day-night cycles, so that their day lasts less than 24 hours, and that it can lay more eggs. They can be more productive. While this is not strictly, it's a lighting problem, but it's not connected, of course, to urban lighting per se. The examples on the right, we know that we have an impact on the behavior of animals. And it's a well-known example, this one of turtles that just go the wrong direction, because instead of following like the moon and going towards the sea, they go in the opposite direction, where there might be, I don't know, a night, a bar, or some other kind of lights. So the impact on wildlife in general. Rather surprisingly, in the literature, current literature, there is also quite little about the effect from an ethical point of view, of course, from the light pollution, the problems the light pollution provokes on human health and human well-being. When we talk about human health, we can think about human health for everybody, but also an individual, for the health of individuals, which is affected by lights. And we can envision interventions that can benefit individual people. When we talk about well-being, we are already moving into the sphere of public health, in the sense that we live either in cities or in other settings, but we tend to live in communities, and we use and we take decisions, or we should take decisions together about what is the best lighting for where we live. But now we start to be aware, and we are starting to listen to the fact that to those that tell us that lights can really affect our health, and it is a huge public health issue. We can envision intergenerational dimension of this human health problem, because we know that there are problems connected to, for some groups, excessive lighting is a problem more than for other groups. For vulnerable people or vulnerable groups, this is almost a problem, for instance, for the elderly, or for people that already have underlying mental conditions. And on the other end of the spectrum, there is still the problem of lighting poverty, which is exactly what I said, the opposite. The fact that in certain communities and in the links towards those communities, there is villages, for instance, there is little light, and it's dangerous. And then there is an intergenerational dimension, because it will be always more and more hard to the example in the picture where someone is pointing at stars, I like to think that it is a parent that is just inventing the name of constellations, and this task will become always more and more hard, and the new generation will be deprived of those of darkness and what it entails. Plus, they will face the problems coming from all the pollution that is generated to produce excessive light. And this is what I found with some of my interpretation within in the literature. Now, what I would like to do in the rest of our work, in the ethics of urban lighting, is to amplify a bit, to use more the concept of the environmental justice. Now, the core of environmental problems is that they cause inequalities. Most of the time we talk about inequalities between people because the anthropocentric paradigm is winning. It's always winning. And at most we can talk about inequalities between living and future people. According to Buller's influential definition, environmental justice is the principle according which all people and communities are entitled to equal protection of environmental and public health laws and regulation. The principle is the theoretical foundation at the basis of decades of claims that exposure to pollution and pollutant and other environmental risks is unequally distributed between people. And I think it is the case also with light pollution, and that's why I think it can be used with profit as a frame, not to substitute light pollution, but to integrate it for our purposes, to analyze it and convey it in a language, in terms that can be understood, that are already established. So as I said, it can be used to talk about public health problems, but I think that the principle could be extended also to all living entities, such that the circle of entities whose interests should be taken into account when planning lighting policies would include also animals, species, plants, and ecosystems. The environmental justice principle should not be extended to other entities only just following the extensionist paradigm, so just the typical move of extending the circle, and whenever our interests conflict, we come back to an anthropocentric core, because that's what we most of the time we do, essentially. I think that it should be inspired, the environmental justice principle should be complemented, should be work together with the One Health approach to global problems, and lighting is a global problem. So recognizing that this entails recognizing that optimal human health is achievable, recognizing the interconnection between people, animals, and their shared and our shared environment. That's it. That's my presentation. Thank you very much for your attention. I will now stop sharing it.
Thank you, Mirko. And we kind of go back to some of the concepts we have been tackling in the morning about justice distribution and how we protect rights, not only of humans, according to your presentation. Very interesting to look also at the other approaches that are not only the anthropocentric approach. So I think there is actually quite a bit to look at in these ethical aspects of urban lighting that hasn't really been looked at a lot, because we're always in a very anthropocentric view somehow. And if you even look at the focus of this project has little to do with the environment or ecology, because of course it's not the focus of that. But it's quite interesting to bring this dimension into that, especially since environment and environmental issues are kind of tackling every aspect of our life and will be more and more relevant for the future and for the future of our children as well. I had a question, if there isn't anyone from the public that wants to intervene, as there is an interesting case that just happened in South Tyrol in Italy, in my region. So the president of the region actually tries to introduce some laws in order to limit the light in shops during the night for ecologic reasons, exactly for avoiding animal harm and reducing light pollution. But on the other hand, we have the opposition that is really like crying out that he wants to kill security in the city, and that
I'm sorry, I
yeah?
lost you for a couple of seconds.
So
Who
like
is
the opposition, who is
Deborah, I'm sorry. I think that is better that you close the video because
fine.
Yeah. Thank you.
So the opposition is, well, a right-wing party in our case, and they are crying that closing the shop lights at night would really create security issues for the city. And here we are talking about a very small city that doesn't have really like high crime levels, etc. But it's quite interesting to see the different values that are opposed somehow. Do you have some comments here?
Well, yes, thank you for your question. Well, the very first thing that comes to my mind is that of course, we are all concerned about the safety of people. However, there might not be the basis for this concern, in the sense that there is not much of that, but some studies that have, let's say some studies that have been performed in different countries in different settings have shown that actually the safety of people is not enhanced by the more light, and sometimes somehow the experiments gave counterintuitive results, namely that in areas that were more where there were more lights, actually there was more crime. Of course, one can't just think that more lights attracts the criminals or provokes their actions, but is just to say that more lights does not entail more safety for people. However, there is a psychological dimension to keep into due consideration, the sense that we tend to believe that we are safer where there is more light. And for some people, or for all of us, I mean, to come back home at night in an area where there is a very poor light, even though we may not be exposed to higher risk due to the lack or to the lack of light or to diminished level of light, can anyways make us feel concerned, make us feel anxious. So there is a need to be somehow taught, educated about this aspect. Anyways, it's not a problem that arises when we talk about shops. If there is just less light in a shopping center or something like that, that should really not cause any kind of problems, in my humble opinion.
So I have a more general question that tackles both of you, and is about how much this dimension should be explored and maybe introduced in a project like this one, where we are actually asking people how they feel about light, how we should plan our urban lighting procedures, etc. Is this dimension underrepresented in the project, in your opinion? And how could we introduce it? Has this implication for the research integrity of the project as well?
I think it is. I think the presence of what I labeled the framework 2 could be so the fact that urban lighting is something that affects more than our vision should be, and our health could be more present in the project, and therefore in the communication with those that will be involved, and that will help to create the settings, for instance, in the 3 cities that are involved in the experiment. Because most people are just not aware of the ecological dimension or dimension of the harm to the animals, to the plants that comes from the way we use lights in cities. And they may not care. I mean, for instance, the public or large portions of the public may just not care about it, but we should tell them that also this is something that we can take into consideration, where if most of all if it brings to different decisions, but even if it does not bring to different decisions, it's probably part of our duty as researchers to inform them.
Yes. Elisabetta, is there something?
I do agree. Nothing to add. But I mean, it's an important dimension to include. It's not compulsory, of course. It's not a matter of violation, but it could be important to enhance also the importance of the research in this sense.
Somehow I have the feeling that is not only a matter of awareness, which is one level for which people may not tackle this issue when we focus on certain topics, but also a matter of awareness for researchers, because we have been focusing on how we build lighting policy, how we build the health of people around light, etc., but less on those other topics somehow. And this may have, roots in the fact that we are working with people that are building lights environments, so not really into the ecologic dimension, but also about the fact that how we frame our social research does not ask the question. I'm not sure if there aren't people out there that are worried about the light pollution, for instance. I know that in many countries, especially in the Nordic countries, etc., there is a deep awareness of light and how light impacts our lives, for instance. So I'm sure that people will have considerations about it. What do you think? Is it also how we frame the questions that is impacting? And this has direct consequences on how we kind of act as complete researchers in a way.
Yes, I agree, but I also understand that people that works practically in the design of lights in a city may not be, not that they don't know, but may not be primarily concerned with the effects of lighting and the what it entails for the environment or what it entails for the wildlife. Sure. Although they know it, of course, and to a certain degree, I guess that they also may take it into account. I guess that this kind of consortia may provide, by the fact that different researchers, I mean, with different backgrounds, different areas of expertise are involved, can build something together that, and through repetition, because things have to be repeated many times, can enter in also different consideration from the anthropocentric considerations, can enter into, for instance, even into policies, into policy making.
Mm-hmm. Yeah,
Yes, I agree with both of view and the social scientific relevance, but also of research, but also the protection of environment, animals, and so on is one of the main topic in research integrity. And there's a problem of how to ask questions as researchers, and then of course it's also difficult to address too many issues in a project, probably. But I think that we should work on the awareness also of these issues, of these problems.
so I will start to wrap up unless we have questions from the public. Are there any questions? Do you want to raise your hand? Then I would say that in the presentations today, we saw like problems of balancing different interests in how we can use and exploit data and samples, how we need to balance rights and the need to perform good science, how we balance different values in measuring what is interesting and important while shaping light policies. And I think that this balancing center somehow leads also us to a very important consequence of this workshop we had this morning, and is the need to make researchers aware of the broader dimension of the research that we are doing and of different aspects that we may have to take into account. So I would potentially conclude here for today, unless there are comments on the public side.
No, Deborah, I just want to thank you for chairing this session, and congratulations to all the presenters, because the presentation were very, very interesting, and it was a pleasure to hear you. And I just want to recall that today in the afternoon we have the plenary session, so you are all invited to participate. It's at 3:30. And Simona Tondelli, who is the project coordinator, will chair the session, and we can have a wrap up of all the conference.
Thank you very much. Goodbye to everyone.
Again.
Bye.
Thank you. Bye.
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 Bye.